The Seeking Justice podcast crew acknowledge the First Nations peoples of Australia, specifically the Yuggera and Turrbal peoples of Meanjin and Brisbane, the traditional custodians of the lands on which we live and work. We acknowledge that their sovereignty was never ceded. We pay our respects to their ancestors, their descendants, their elders past, present and emerging who continue cultural and spiritual connections to country. We also acknowledge the need for all of us to reclaim our own indigeneities from the lands from whence we came. Welcome, Justice Seekers. I am very excited to introduce our guest for episode 6 is Professor Ben Saul, the Chalice Chair of International Law at the University of Sydney and the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. Professor Saul is an elected Fellow of the Australian Academy of Social Sciences. He was the Gough, Whitlam and Malcolm Fraser Visiting Professor of Australian Studies at Harvard University in 2019 and also a former Associate Fellow of Chatham House in London and of the International Center for Counter-Terrorism in The Hague. He's published 20 books, over 100 refereed articles and hundreds of other publications, made hundreds of scholarly presentations and been awarded millions of dollars in research grants regarding his areas of speciality. His research has been used in international and national courts, and he's been involved in over 130 parliamentary inquiries. His book, the seminal text Defining Terrorism in International Law in 2006, remains the leading work on the subject, and he's also the lead author of the Oxford Commentary on the International Covenant on Economic, Social and Cultural Rights in 2014, and also the Oxford Handbook on International Law in Asia and the Pacific 2020, and the Oxford Guide to International Humanitarian Law in 2020. Professor Saul's taught at Oxford, Harvard, The Hague, and other academies of international law in China, India, Nepal, Cambodia and Italy, and given lectures in various institutes all around the world. He was lead counsel in 5 successful national security cases before the UN Human Rights Committee, and that also included David Hicks in 2016, the unfair military trial at Guantanamo Bay. Obviously, David Hicks was detained a lot earlier than that, but the wheels of justice can turn slowly sometimes. He has advised or consulted to multiple United Nations and other international bodies, governments, militaries, judiciaries and NGOs, and delivered technical assistance in developing countries. I'm very pleased to welcome Professor Ben Saul. And we want to discuss a range of topics today. But firstly, Ben, how are you?
Not bad, thanks, Benedict. Good to be with you.
Are you just back from overseas?
So I've just been at the Human Rights Council in Geneva to present my latest report, annual report, which is always on a new thematic issue where we try to kind of move the dial on human rights and push standards forward in a new direction.
And I have seen from your report last year to the General Assembly and from this recent report in February to the Human Rights Council, you have been extremely busy and including your focus on West Africa, the country visits to Cote d'Ivoire and Benin. Can you talk about that focus?
Yeah, so I guess the focus for special rapporteurs is partly reactive to events in the world, and in the case of West Africa, of course, there's a real problem of jihadi terrorism in the Sahel, countries, and that's been spilling over to the Atlantic coast countries like Cote d'Ivoire and Benin, and they've had to mobilize their military as well as police and gendarmerie to try to confront that threat. So Africa, West Central Africa, as well as in the south, Mozambique is pretty hard hit. In a month or so, I'm off to Somalia in East Africa, which has been heavily affected for many years now. So obviously, those kinds of priorities present themselves. Likewise, in the Middle East, Gaza over the last almost 18 months has been a bit of an epicenter of international debate about terrorism and counterterrorism.
And your mandate is extremely broad in the sense of a fairly contentious, cutting-edge area, but also the global remit, as it were. And there's so much happening in this space. How do you decide what to prioritise under the mandate?
You're right that it's a cross-cutting mandate in the sense that pretty much every human right you can think of is affected or can be affected by terrorism or counter-terrorism in some way. And so the core of the mandate is to monitor states while countering terrorism to ensure that they don't violate by committing torture and forced confessions, unfair trials, summary executions, counterterrorism sanctions, which don't provide due process or judicial safeguards, measures to restrict free speech, to prevent hate speech, violent speech, terrorist speech, etc. We cover 193 countries. We also cover the whole UN family, which has about 46 or 47 entities across the UN system, which are involved in counterterrorism in some shape or form. And that includes, right up to the Security Council and the General Assembly, down to entities in the field like the UN Development Program or other kind of operational agencies doing things to prevent and counter violent extremism or terrorism. So, look, in terms of priorities, we talked already about geographic priorities, but in terms of other priorities, it depends a little bit on who is violating human rights in the worst ways, and that obviously attracts our interest. It depends a little bit on other mandate holders because, of course, there are other special rapporteurs who cover different issues. So it might be that even if a state is torturing to counter terrorism, that the special rapporteur on torture might be better placed to deal with that particular case because we bring what we call communications, individual cases, to the attention of governments through a formal diplomatic procedure. We also review legislation, and lots of countries adopt new laws against terrorism all the time. And then, as I mentioned in our thematic reports to the Human Rights Council and the General Assembly, that's where we can be a bit more strategic and kind of pick the issues that we want to take forward, above all the noise of what's going on in the day-to-day in different countries. So it's a mix in that sense of reaction and being proactive. We're woefully under-resourced. Obviously, the UN has no money, and it's getting worse because big donors all over the place are unfunding lots of UN programs and entities because of their own budget crunches at home or because they're spending more on defense in this big, challenging geopolitical climate. So it's tough times for human rights, I'd say, across the system.
Absolutely. And I was going to say all of those issues in West Africa are obviously not on the front pages of the broadsheets across the world, go, relatively unreported by mainstream media, but yet other issues that would touch on your mandate, obviously what's happening in the United States now, what's happening with the Israel-Gaza issues, come to the fore, and there must be a lot of urgency. Well, there must be a lot of urgent issues that also come to the attention, along with the more long-term visions you have for progressing the mandate. I note the mandate was created in 2005, has been extended a number of times. Is it a contentious, and just on the point of funding, I noted in your latest report there was a note to Spain and Switzerland for providing some funding. But are the mandates ever contentious amongst member states? Are they happy to extend the special rapporteur mandates because you need to obtain access to countries in any event? So they're happy for the mandate to exist, whether it actually comes to bear scrutiny on their state is a kind of separate question in a sense.
Yeah, it's a timely question because my mandate is up for renewal as we speak at the Human Rights Council. So at the end of the current session, which is in a couple of weeks' time, the resolution to renew the mandate for another 3 years, because that's our cycle, is up, and the negotiations are going on this week, actually. And without commenting on specifics, look, I would say, of course, many mandates are politically contentious from time to time. That can be because of sometimes ideological differences between different states or groups of states about which human rights ought to be emphasized. For example, economic, social versus civil and political rights. Sometimes it can be a question of money. States just don't want to spend more money on mandates, and sometimes it can be simple retaliation. Some countries don't like what you might have said about them, and so they get the way they can get their revenge is by opposing the mandate or trying to defund it in some way. Some mandates are more controversial than others, and some have, I'd say, different blocks of states behind them, because some mandates are formed in a particularly politicized fashion, and so that can reflect real divisions over what the human rights movement should be focusing on. So, yeah, although the mandate is in some ways it's a legal one because my mandate is to apply international legal standards on human rights to the behavior of states, but there's also a lot of diplomacy and politics behind the mandates, of course, as well, because states create them. States are political beasts, and states want to shape the human rights system in ways that are favorable to them.
Yes, indeed. And I note that you're appointed in November 2023, obviously very close proximity to the events of 7 October 2023 and the aftermath of that. And you have been part of putting out joint statements with special rapporteurs on a range of issues, most recently with regards to the United States, with regards to Mali, alleged arbitrary executions there on the 14th of March 2025. And then back in, I think it was 16 November 23, there was also condemnation of the disproportionate retaliation by Israel against the Palestinian people. Is that it? Are these joint statements becoming more common? I'm not sure if you know prior to your appointment, but it seems to be there's a lot of this very constructive coordination between the different mandates and where there's overlaps.
Yeah, certainly there is a lot of coordination for a couple of reasons. One is that member states want to see that. They want to see that the system is a kind of coherent one where there's not duplication and overlap and a bunch of independent experts doing or saying different things on the same issue. But at the same time, from the mandate holders' perspective, it's also useful because it, collaborating with other mandate holders amplifies our message, makes our voice stronger, and the more mandate holders, the merrier in terms of the impact that message can have. I mean, obviously, that itself raises issues because, as independent experts, we are also independent of each other, and so we won't necessarily always agree. And different mandate holders take different interpretations and perspectives on human rights on occasion. So there is a process of compromise that goes into these statements. I might sign on to a statement when I'm not necessarily 100% in agreement with everything in it, but that's the price of collective action. When there's a country mandate holder, so in the case of Palestine, there's a special rapporteur on the occupied Palestinian territories. They are by custom they have the lead on their on statements and communications affecting their mandate. So they have a particularly influential say, I'd say, on how those statements are crafted. But look, there's good cooperation with mandates like that, and often other mandate holders will take the lead, and then the country mandate holder will sign on and give feedback and so on. So it's a pretty cooperative system by and large.
And going back to you talking about resourcing, do you have a team? Is the position funded? I note you're the Chalice Chair of International Law at the University of Sydney, and you've had a very highly esteemed career in all of the amazing work that you've done. Do you take a sabbatical to do this position, or how does it work?
Yeah, so special rapporteurs are unpaid volunteers, I guess, because the UN doesn't have money to pay us, and that's fine by me. We do have a small team at the UN Human Rights Office in Geneva. So each mandate holder will have their own team. So they're full-time UN employees, human rights officers, paid to support the mandate. It works pretty well. I mean, obviously, I'm an independent expert, so I'm free even to criticize, the UN Human Rights Office. Although my staff are UN human rights people, they, in a sense, work for me, not for the office as such. And by and large, that works pretty well. What a lot of mandate holders do also is then sort of try to scrabble around for all kinds of external resources as well. So I use quite a few student law clinics in the United States. I've had some paid research assistants. I use some paid consultants from extra budgetary contributions I fundraise from different states who might be interested to support the mandate. But in terms of the regular budget, the member states of the United Nations give me one paid staff member in Geneva, and then we have to supplement that. And now, that's clearly woefully inadequate to cover, monitoring 193 countries, 47 UN agencies, doing country visits, writing annual thematic reports, issuing press releases every week. I mean, last year we did over 110 communications to states, and each one of those is about 5,000 plus words. So that's 2 a week. So it's and to an extent, I think this is deliberate on the part of states. I mean, many of them want to create a kind of cosmetic human rights monitoring system, but then don't give it the resources to be as effective as possible. Now, I do think mandates can be pretty effective, but they do rely a lot on a lot of unpaid labor, a lot of sometimes philanthropy. The difficulty at the moment is that, as I mentioned, funding is being cut back across the board. That includes philanthropic funding. It includes development aid from a bunch of countries, not just the US. I mean, the UK, Netherlands, Switzerland, Belgium. A bunch of traditional donors are cutting back in a big way, and that's I think really undermining not only us but all of our partners, because we use and rely a lot on civil society organizations, NGOs around the place, and a lot of them these days are just folding or shedding staff. because of that funding crisis across the system. I mean, even whole UN agencies are at risk of collapsing, including UNRWA, UNAIDS, others massively downsizing. So I think it's a really dangerous moment actually for human rights and the multilateral system generally.
Absolutely. And yes, states like this performative posturing on human rights and, as you said, the cosmetic superficiality of it without then resourcing it. But I dare say they didn't bank on the indefatigable Professor Ben Saul because, with a small team, the amount of output of, product, to use crude terms of productivity, but it's quite incredible. And if you're also having to negotiate country visits, which I imagine takes a lot of work, and then also writing those reports, dealing with individual complaints, all of the above, and then coordinating with other mandate holders. I mean, it's incredibly admirable and inspiring. And so thank you for your work, and obviously to all of the mandate holders as well. In terms of a dark time and a dangerous time, I did just have a, comment question about what the heck is happening to the rule of law, the international rules-based system, when we see, and I saw you'd signed on to a joint statement about the kidnapping and detention of Mahmoud Khalil as a, quote, terrorist sympathizer in the US, the pro-Palestinian permanent resident from Columbia University who was kidnapped into ICE custody, no due process. And then, of course, we have over 200 Venezuelans who were extraordinarily renditioned to a supermax hard labor camp in El Salvador. No due process as required under the 5th and 14th Amendments of the US Constitution. And again, this terminology of terrorism, terrorists being bandied about to justify these flagrant violations of fundamental legal principles. Can you talk a bit about, your perspective and elaboration on that dangerous times that we're in, but certainly looking at the United States that was meant to be a beacon for, rule of law, due process, etc.?
Yeah, well, look, thanks, Benedict. And I think you've outlined a lot of the concerns that I would share. I mean, certainly, in this job, really there are sort of two trends we see. One is the violation of the human rights of people who are actually genuinely suspected of terrorism. But a lot of what we look at is precisely along the lines of what you've suggested. That is, people who are not by any stretch of the imagination terrorists. They're not involved in the commission of terrorist violence properly defined according to best practice international standards. But states nonetheless misuse or abuse counterterrorism laws to suppress political activists, journalists, dissidents, minority groups, universities, targeting migrants, cracking down on free speech. So this is actually a big part of what we see, and it's not just the present moment, and it's not just the United States. I mean, this is something that's been going on a very long time since 9/11. It's a pretty widespread pattern of abuse against civil society in a bunch of countries. Obviously, it's of huge concern when a country as influential and as powerful as the United States starts modeling that kind of behavior as well. I mean, some of this, I think, does stem back to what's been happening in the Middle East. For a very long time, Israel has been misusing or abusing counterterrorism narratives and laws to combat not only genuine terrorism, but also to target civil society and NGOs and human rights advocacy groups and so on. Over the past 18 months in the Middle East, we've seen large-scale systematic violations of international humanitarian law by Israel as well as Hamas, and not just in Palestine, but in neighboring countries as well, in Lebanon, Syria, Iran, Yemen. And throughout all of that, the United States, even under the previous president, Joe Biden, was arming and financing and supporting with intelligence the Israelis to commit those violations. Now, that's in clear violation of the US's own international obligations not to be complicit in international crimes and violations of humanitarian law, its obligations not to transfer arms and munitions when there's a real risk that they would be used in those violations by Israel. And with the Trump administration, that's just gone to another level. I mean, at least President Biden imposed some constraints on Israel's use of weapons and withheld some weapon shipments and had some guidelines in place to vet the provision of weapons. A lot of that has been loosened under the Trump administration, and a whole lot of new weapons have been provided without seeming much conditionality to take into account humanitarian law at all. At the same time, the phenomenon that we've seen in a bunch of particularly Western countries is the kind of crackdown on freedom of expression, legitimate expression, critical of the way Israel has been conducting the war. And some of this expression has been suppressed on the basis that it's anti-Semitic or it's supportive of terrorism. When, according to international human rights law standards, the suppression of speech in those circumstances is clearly excessive and disproportionate and not justified to meet legitimate objectives like preventing violent speech or hate speech. But goes beyond to protect against political views you just don't like or political criticism of the US's ally, the United States. So deporting people for their free speech is really taking it to the next level. This is pretty authoritarian and unexpected for the United States, that's for sure. You mentioned the Venezuelan gang members, so declaring them a terrorist organization, using wartime enemy aliens laws to deport them without due process and without consideration of protection against inhuman treatment on the other side when they get to some pretty appalling El Salvadorian prisons. I think this is really showing a serious contempt for international law.
And even domestic law in the States. I mean, we now know that one of the men was a gay hairdresser who had fled to seek asylum. Another one was a professional football player who had a Real Madrid tattoo that they said, oh, well, you've got a tattoo, you must be a member of Tren de Aragua, you're a terrorist, get in the plane. I mean, it's just... it's really quite mind-boggling. But just to get on to the topic of the definition of terrorism at international law, which doesn't quite exist yet, but is in some form of development. Now, you are the author of the leading and seminal text, which is now almost 20 years old, from 2006. How are the developments happening in terms of defining terrorism in international law? And then obviously there's an interesting intersection perhaps between international humanitarian law, war crimes, crimes against humanity perpetrated by states. So, for example, you could perhaps define a terrorist act also could be construed as a war crime or a crime against humanity, whether under the Rome Statute or the Geneva Conventions or whatever. But I'm just interested as well, because I wanted to posit the idea that under Australian law, the Commonwealth Criminal Code, there is, of course, the definition of a terrorist act, not terrorism per se. And it's in section 100.1 of the Commonwealth Criminal Code Act, and an action is done or the threat is made with the intention of advancing a political, religious, or ideological cause. And then there are other offences about providing or receiving training concerned with terrorist acts and possessing things concerned with terrorist acts. And there's a extraterritorial application in the Commonwealth Criminal Code. But is that, I mean, I presume it's been contemplated, but is that a useful framing in international law as a terrorist act as opposed to terrorism per se?
So you're right. The international community has been trying to define terrorism for about a century without success. There is, at the moment, a draft United Nations Convention, which has been under negotiation since about 2000, 2001, so 25-year marathon, and they're still stuck on that one. I think there is a kind of increasing consensus based on a couple of sources, like the Terrorist Financing Convention, which has a sort of a general definition of terrorism, and Security Council Resolution 1566, which is that terrorism is a criminal act which intentionally causes death or serious personal injury, and it's done to either intimidate a population or part of it, or to coerce or compel a government or an international organization to do or refrain from doing something. In other words, it's a kind of instrumental kind of violence against people. Now that's the kind of, I'd say, the minimum consensus. Lots of national laws go well beyond that, and for example, include harm to or damage to property, not just people. Some include economic harm, harm to sort of critical infrastructure, including financial or electronic infrastructure. So there are lots of wider definitions out there. Australia, in some ways, narrows the definition in a couple of ways, because in addition to intimidating a population or compelling a government, Australia requires a further intention element to advance a political, religious, or ideological cause. So it's not just intimidating people, which organized crime does and mafia does. It's got to be politically motivated, intimidatory violence. And that's kind of salient at the moment, because in Latin America and in Trump's United States, a bunch of countries have lately started to designate drug cartels as terrorist organizations, instead of just as organized crime gangs as they were previously regarded. Look, I'm not so concerned about whether you define terrorism or terrorist or terrorist act or terrorist organization or terrorist offense. I think what matters is that however you define it, it complies with human rights law. So that means it's got to be comply with the principle of legality and non-retrospectivity, which means offences have to be sufficiently clear and precise and not overbroad, so that they're not prone to abuse, misuse, so that they don't infringe on fundamental rights, including freedoms of expression, association, religion, assembly, etc. And if you get all that right, then I think it is possible to define terrorism and terrorism offences satisfactorily. But one of the problems we often see is that you get a bad definition of terrorism, and then you get really bad definitions of terrorist offences on top of that. So there's this kind of compounding or cascading effect of human rights inconsistent terminology in the law. Particularly offences relating to terrorist organizations, offences around, mere membership or association or providing support, receiving support. A lot of the time these offences don't involve any element of furthering violence or participation in violence by the terrorist organizations. And so they're, in that sense, massively overbroad and start criminalizing a bunch of really quite innocent conduct, or conduct that is really far too remote from terrorist violence to justify criminal sanctions. Likewise, we mentioned speech. Fine to criminalize incitement to terrorism if that's proximately connected to the commission of violence. But what we often see is offences like, merely praising or glorifying or advocating or apologizing for terrorism, which captures a whole range of speech which really ought not to be subject to criminal sanctions.
And often there would be other laws that can deal with those issues, whether that might be incitement laws, hate speech laws, or another example from the United States is Elon Musk and Donald Trump calling the Tesla protesters, and I think all of them, whether they're peacefully protesting, and obviously there's been vandalism, but they can be dealt with under vandalism laws, presumably, rather than being labelled domestic terrorists, and which seems to be more and more now used as a convenient and perhaps malevolent political device in order to strip people of their rights if they're deemed to be a terrorist from whichever perspective. And it just brings me to the idea of designating terrorist organisations. And I know you've spoken about this, but for example, I think it was the 4th of March 2022, the former Home Affairs Minister, for example, designated Hamas a terrorist organisation. Now, their paramilitary wing had been designated since, I think, about 2003, but then this encompassed the whole organisation under Division 102 of the Commonwealth Criminal Code Act. But it just raises interesting questions in circumstances where even the Israeli media has been widely publishing on the fact that Prime Minister Benjamin Netanyahu was allegedly funding Hamas to the tune of millions of dollars through Qatar as part of a broader strategy to divide the Palestinian Authority and Hamas, and the move away strategically from a two-state solution. And then, of course, you've got the National Security Minister Itamar Ben-Gvir, who was actually convicted of support for a terror organisation. So it's very interesting where this term ends up and how it is used in terms of proscribing, legitimately proscribing conduct, as you said, but also perhaps more politically proscribing conduct.
Yeah, that's right. And you raise a couple of issues. One is the way in which terrorism laws are being applied to criminalize a whole lot of what would normally be seen as ordinary offenses or even public order offenses. So treating protesters who, break into an arms factory like terrorists instead of, prosecuting them for trespass or property damage or all the other things in the criminal law book you could throw at them. On organizations like Hamas, certainly, one of the concerns we've had for a long time is terrorism laws which criminalize legitimate humanitarian assistance under international humanitarian law. So you criminalize an organization as terrorist and criminalize various forms of engagement with it as terrorism. And that has the potential to then criminalize as terrorists people who are providing humanitarian relief, medical services, food to civilians who are starving in war zones. And of course, that kind of activity is precisely protected under international humanitarian law because civilians should not be, should be entitled to receive minimum humanitarian relief, including to receive outside assistance. At the same time, we've seen lots of banks and financial institutions de-risking. So because they don't want to fall foul of counterterrorism sanctions or terrorist financing laws, they just withdraw from areas like, say, Somalia during the civil war previously, because they don't want to get caught up in regulatory action and be accused of, somehow facilitating the financing of terrorist groups, terrorist organizations. Now, there's been some good work on that recently. Last year, the Security Council finally adopted a permanent humanitarian exemption to counterterrorism sanctions, so that if you are providing humanitarian relief It should not be caught by counterterrorism sanctions in relation to, Al Qaeda, ISIS, Al Shabaab, these kinds of listed organizations that are listed by the Security Council. So that's a positive step, but there's still a lot of work to be done in implementation for sure.
Yes, and just one question to your, I guess, expertise and perhaps outside of your mandate, but in terms of international law, I'm interested in the context of what has been happening in Gaza and with the Israeli conduct. And I know that yourself and other special rapporteurs have come out and condemned the breaches of international law by both Hamas and Israel. But in terms of what could the Australian government be doing, and I'm quite perplexed with the very clear obligations under the Genocide Convention, for example, to prevent and punish genocide. And whatever state parties were thinking at the time they signed that, whatever a future genocide might look like or not look like or be politically convenient or politically inconvenient. But one historical comparison is, of course, former Prime Minister, and the context, of course, is the International Court of Justice's unprecedented or new precedented landmark rulings on the apartheid illegal occupation of the occupied Palestinian territory, and that is in train that needs to be completely dismantled by September this year, and then obviously the plausible genocide finding. But former Prime Minister Bob Hawke, through his role at the Commonwealth Heads of Government meeting, he played a leading role in ensuring the Commonwealth, the whole Commonwealth, initiated an international boycott on foreign investment into apartheid South Africa. And that was, he even got into arguments with the UK Prime Minister Margaret Thatcher about it, held the line, and that was widely credited with collapsing apartheid. Now, that is obviously a non-violent way to intervene, and this is perhaps a contrast to what the Houthis in Yemen say that they're doing in terms of the Red Sea blockade and the strikes on Israel, because they say they're adhering to the Genocide Convention. But just going back to these non-violent, I guess, means of the ways that countries can fulfill their international obligations without direct military intervention, as it were. Do you have any thoughts on that in terms of where Australia stands in the world?
Yeah, thanks for that. And look, Australia, like any country, has lots of potential tools at its disposal to encourage states that are violating international law to come back into compliance with it. I mean, certainly we could do more to support international institutions like the International Criminal Court, which has arrest warrants for Israeli leaders. We could intervene in the International Court of Justice proceedings to try to hold Israel to account. We can support General Assembly resolutions and switch our votes on ones where we've been historically not so good at upholding international law. We should call, more meaningfully for action to address the root causes of the conflict. As you said, the International Court of Justice has said Israel has to end the illegal occupation, and the General Assembly has given Israel a date for doing that. And under the UN Global Counterterrorism Strategy, all states have committed to addressing what they call the conditions conducive to terrorism. That is the root causes, which are things like unresolved conflict, political exclusion, state violations of human rights. All the things that are there in spades in Palestine for many, many decades. It's also lawful for Australia to impose sanctions on responsible Israeli leaders, military and civilian. In fact, we've got a Magnitsky Act, which is one of these kind of human rights-based sanctions tools, which we've used against the likes of Iran and Russia and Myanmar. There's no reason why he couldn't use that against the Israeli leadership as well, to kind of send that signal. Even if they don't have assets in Australia, as they probably don't, and if they're not intending to travel to Australia, at least it sends this kind of signaling message of condemnation and ostracism, and treats them the way we would treat any other serious violator of international law. So I think certainly Australia, like most countries, frankly, can do more and do better on this front.
I'm particularly interested, and I think people will be interested in the fact that your mandate also includes victims of terrorism. And so you might get individual complaints, or you might look into those issues. And I note that you put out a recent statement on justice for victims of the 9/11 terrorist attacks. So is there still an issue outstanding there?
almost 25 years on, the some of the main perpetrators of the 9/11 attacks have still not been held to account through a fair, independent, impartial criminal court system, right?
Yes.
The US, as is well known, came up with the military commission system after 9/11. It was meant to, provide for speedy convictions. Quarter of a century later, those masterminds have still not faced trial and potential conviction. So one of the elements for victims of terrorism is that they should be able to see justice done. See their perpetrators convicted and punished. And if you create a kind of utterly unfair military court system, which is inconsistent with international law, can't guarantee fair trial, international standards, then you deny victims the chance to see their perpetrators put in jail. On top of that, you torture them. It makes it even more difficult to get trial and conviction. So I think victims' families have been waiting a very long time, and it's wholly on the shoulders of the United States that they have denied their own citizens and foreign nationals justice for those attacks.
And are those people still in Guantanamo, I understand, or some of them?
That's right. There's about, in total, around about 30 people still in Guantanamo. A very small number of them, literally a handful, are subject to criminal trials. The rest are kind of waiting to be released to some country that will take them. And then there's a group whose status is still being determined.
And finally, thank you again so much for your time, your precious time, and all the work that you're doing. But I just wanted, especially for any law students or early lawyers who want to move in a direction of international human rights law. But what motivated you to pursue a career in international law, international human rights law, and were there any particular people who inspired you on your journey?
Yeah, so I first got interested because of the refugee issue here in Australia. So, I worked at law school at Sydney University. I worked on some cases concerning, victims from of state violations of human rights from various places, and saw the power of the law to help people, protect them, assist them when they're victims of that kind of state, those kind of state violations. I had a chance to basically intern with UNHCR, the refugee agency in Nepal, and Bhutanese refugee camps for some months, and it really helped to demonstrate the power of international law to provide kind of substitute protection where states themselves are failing to live up to their own responsibilities. And so that's, I guess, where it began. And then I, went off and did further studies on international law and got deeper and deeper into it. Lots of people helped me along the way. In the refugee law area, my now colleague, Professor Mary Crockett at Sydney University, helped me get interested in that area. The late Professor Ivan Shearer, when I was studying, was on the United Nations Human Rights Committee, so I had an opportunity to be a research assistant for him, including in Geneva, and that was my first kind of exposure to the wider UN human rights system. So all of those kinds of interactions really help you to get a sense of what human rights is about, and what are some of the pathways to get involved with that.
Wonderful. Thank you so much, Special Rapporteur Ben Saul. Take care. Good luck with it all. And hopefully we can have another chat with you at some time.
Great. Thanks, Benedict. Good to be with you.
Thank you.